There's an absolute obligation in California to track lunch breaks contemporaneously. What does contemporaneously mean? It means to the minute. When businesses get sued in these types of class action and PAGA lawsuits, we say in my industry, the devil's in the data. So when you have to prove that you've got a lawful meal period or lunch break policy, it's all about the time records. You've got punch out for lunch records and punch in back from lunch records that are at least 30 minutes, uninterrupted, off duty. And that means that your employees have to be free to go and do as they please, meaning they're free to leave the premises. Most often, my clients are surprised at short lunches. They'll see a bunch of 29-minute lunch breaks, and that's so preventable. So one way to combat that, give a 35-minute lunch break. Or work with your payroll or your timekeeping provider and put in a lockout feature and make it so that if they try to clock in early, they get that or some kind of error message, and they can't clock in until at least 30 minutes have elapsed. You eliminate the possibility of short lunches. If your employees work more than 10 hours in a shift, they're entitled to a second lunch break. And that's an absolute obligation. Some employers don't recognize this. You get a 30-minute second off-duty uninterrupted lunch break after 10 hours. And you have to make sure they take it. And it's the same type of math, same type of thing. Count it out the same way. There is a way to waive lunch breaks in California, meal periods. If you work between 5 and 6 hours, you can waive in writing the first meal period, but it has to be between 5 and 6. If you work more than 6, you can't waive it. You have to take it. If you work more than 10 hours and you're entitled to a second lunch break, you can actually waive your second lunch as long as you don't work more than 12. So last thing on meal period rounding, I mean, it's pretty basic. Just don't do it. You want to see that some meal periods are 31 and 32 and 33. If they're all 30, there might be some rounding or there might be something else going on. You want to see evidence of real human behavior. When you have evidence of a meal break violation, which again is, it's missed, they didn't take it, it's short, under 30 minutes, it's late, even 1 minute after the 5th hour, you have an absolute obligation under the law to pay them an extra hour of pay at the regular rate of pay. If you pay the meal period premiums, one of the things you're going to be able to do is take those violations and just wipe them off the board. You've effectively got 100% compliance. That's what you want to see. So you need to have a system where you are monitoring and enforcing every single meal period violation in your timekeeping system, with your supervisors, with your training, with daily interactive attestations asking people yes or no, I took my meal periods. If you have that, you are going to be in the upper echelon of employers, and you're going to be able to rebut any claim that your employees didn't understand their obligations, and you're going to be complying with California law, and you're going to be in the best position not only to fight off a wage and hour class action case, but to prevent a future case.